Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Shafiq Ahmad Rishan. So, to everyone and Sir Hafizi, we are from group in section 2, and today we will present question 1, which is meetings, member resolution and member rights under Malaysian company law. So, the company involved is XYZ Sdn Bhd, a private limited company in Malaysia. The issue here is that XYZ Sdn Bhd has called for an extraordinary general meeting (EGM) to approve a major change to the company constitution. However, some shareholders are resisting the proposals. So don't worry, we will use the ILAC method to analyze this situation, which is issue, law, application and conclusions. Now let's jump into the issue. So the issue here is, what are the legal requirements to convene an EGM in Malaysia? Second is, what is legal role and effect of member resolutions? Last is, what right to dissenting shareholder have under Company Act 2016? So the issue is important because meeting and resolution are core mechanism for shareholder to exercise control, especially in private company, where shareholder often double as director. Now, let's move into the legal requirement for convening an EGM, especially for private company like XYZ. So this is the first issue that we're gonna talk about. So the first one, under section 311 of the Company Act 2016, member are holding at least 5% of company paid up capital can requisition an EGMs. Once the company receives the request, under section 312, say the director must issue a notice within 40 days. Next, under section 313, then state that the meeting must be held within 28 days after the notice is issued. Under section 321, the company must send a written notice to all eligible people, such as member, director, the auditor, if any. And then, in the notice, we must have the first one, the dates, times, venue of the meetings. Next, the agenda, what we will discuss in the meetings. So, this is very important to us, the member, director and the auditor must to know. Last, the full text of any resolution, especially if it's a special resolution. So next is example and clarifications. So for example, if XYZ financially ended in December 2024 and they plan to amend their constitution in June 2025, so they must have 3 things to do to amend their constitutions. For the first one is send a notice of the EGM at least 21 days before the meeting if a special resolution is involved. Second, clearly state the proposed changes in the notice. And lastly, ensure that at least 2 members are present to form a quorum under section 328, unless the constitution state otherwise. So, if these steps are not followed properly, any shareholder could argue the meeting is invalid, and any decision made could be challenged in courts. I think that's all from me, and now I will hand over to Ahmad Adish Afnan, who will explain the role of member resolution in this context. Thank you very much.
Thank you to Arish Shafiq for the wonderful explanation. Now that the EGM is validly called, the next legal issue is about members' resolution. What they are and what they do. There are 2 types, which is an ordinary resolution and also a special resolution. An ordinary resolution is passed by a simple majority, which is more than 50% of votes. This is used for regular decisions like electing directors. For a special resolution, this requires at least 75% of the votes to pass. It is used for more serious matters like amending the company's constitution, which is the situation in XYZ Sdn Bhd. Special resolution requirements. Under section 292 of the Companies Act 2016, the company must give at least 21 days notice for a special resolution. The wording of the resolution must be clearly stated in the notice. The decision is binding if at least 75% of members present and voting agree. So, if XYZ has 100 shareholders and only 60 attend the meeting, at least 45 of them, which is 75%, must vote in favor for the special resolution to pass. Okay, now let's apply this to XYZ Sendirian Berhad. If they gave proper notice and achieved the 75% of threshold, the constitutional change is valid, even if some shareholders oppose it. It is important to understand that in corporate law, majority decisions can bind the minority, but only if the legal procedure is followed correctly. Now, I will pass to Harid Daniel, who will explain the rights of the dissenting shareholders in this case. Thank you.
Okay, thank you to Danish Afnan for the explanation. So now, let's look at the final issue. So, what if some shareholders disagree and feel that their rights are being violated? They are not powerless. The Companies Act provide legal action by 3 sections. So the first, section 210, a shareholder can apply to the court for relief if a company action is oppressive or unfairly prejudicial. So the second, section 114, a shareholder may seek an injunction to stop the company from acting on decision that violate the constitution or the law. So the third, section 347, members have the right to inspect the meeting minutes and resolution for transparency. So also, a derivative action can be taken on behalf of the company if the director are acting improperly. So the next is application to XYZ. In our case, if shareholders feel the change in the constitution is unfair, for example, giving more voting power to one group or removing minority protection, they may go to the court under section 210. But they must prove the process was abused and or they suffer unfair treatment beyond just being outvoted. Just the agreeing with the result is not enough. They need solid legal ground. Okay, to conclude, XYZ must follow all procedural steps to hold a valid EGM. A special resolution passed with 75% majority can change the constitution. Minority of dissenting shareholders can challenge the process only if their opposition, bad faith or a breach of the law. So this case show how important it is to balance the majority's power with the right of minority shareholder. So I think that's all from us. So thank you.